140, People versus Sands. Cassidy, you want any rebuttal time?
Yes, please, 2 minutes.
2 minutes. Okay, you're on. Go ahead.
Good afternoon, Your Honors. My name is Denise Fabiano, and I represent the appellant Michael Sands. A folding knife that does not open and lock, as specifically defined in 265, is a lawful and commonplace
what's required
tool.
here in a misdemeanor complaint as opposed to an information? He waived information, right?
Yes, he did waive information.
So what's required as opposed to the higher, more stringent standards in an information? What's required in a misdemeanor complaint?
We need facts of an evidentiary character giving us reasonable cause to believe that a crime has been committed.
Now, what's reasonable cause mean in this context?
We have to have some assurance that a crime has been committed, that each element of the gravity knife statute has been met.
Okay, what's wrong with this complaint?
Well,
they don't say, we know it when we see it and that kind of thing. They use the language of the statute, don't they?
No, they don't.
What do they use?
They use the language for opens with centrifugal force,
right.
But with regard to the locking mechanism,
right.
They say it locks automatically. End of story. That's not enough to be a gravity knife.
What do you have to say?
It has to lock by means of a button, spring, lever, or other device.
So if they said that, it would be okay, but without it, it's no good?
If they had specified how it locked.
Do they have to choose one of them? Do they have to say it's by spring, say it's by the lock? Or can they, I think, in part, this may be what the Chief Justice is also asking you, can they just re-articulate the language that you find in the statute?
No. I do think they need to be a little more specific, and I think that's under Jackson.
How much more?
I think with regard to the way it locks, they would need to specify how it locks, by a button, by a lever.
So they have to choose one, or the other device.
Well, it's
Can
not
they say,
choosing.
or some other device?
Or it locks by a device.
What about that it just locked?
Well, lock is subject to interpretation, and that interpretation leaves open.
After applying centrifugal force.
Mm-hmm.
I mean, the reason that the statute specifies that it's a button or something else is based on centrifugal force, right?
No.
That's the idea of a gravity
Well,
knife.
the idea of the gravity knife is that it opens with centrifugal force, but that it locks by a mechanism, meaning it doesn't just lock by friction between the knife handle and the sheath. It doesn't just lock by means of a bias towards opening. It flips open, and it doesn't close unless you really push it.
But doesn't the term lock, don't you have to assume that that involves something that makes it stay where it is? Isn't that what lock means?
Lock, actually, according to the dictionary, means motionless and flexible. And a blade that is wedged into place by friction or by a bias toward opening is motionless. And the language in the statute would be superfluous if it just merely had to say lock. Go ahead. I'm sorry.
Okay, what knife do you picture is being included in this charge that would not be included in this charge if they'd used the words that you suggest?
A gravity knife.
No, gravity knives, they count, right?
Yes.
All right. So what doesn't count? In other words,
a folding knife. A folding knife. There are folding knives.
Pocket knife.
A pocket knife.
But they don't lock in place, do they?
There are knives that have a bias toward opening, and there are folding knives that have a bias toward opening, meaning they just flip into place and they remain there. And you could flip it upside down. It's not a gravity knife unless it locks by means of a button, spring, lever, or other device. That's a common lawful knife.
I'm a little confused in that response. Mm-hmm. You're saying that they stay in that horizontal position, that locked position?
Yes.
Not by means of anything internal to the knife, but some external force?
It could be friction between the knife, the sheath. That's actually, I cited something in my brief. Maybe it was Wikipedia. I don't know if that counts, but it says there are knives that do remain open in a motionless position by means of friction between the sheath and the.
But is that locked? Motionless, does that mean locked?
Yes, it's not moving. It's not moving. And,
but if you push it without pressing the button that unlocks it, or if you flip it and it refolds or starts to refold and it's not locked. It's in place and will not move out of that place.
Those knives you would have to push closed. And
You can, without releasing the locking mechanism.
right, but this complaint leaves open the possibility that that type of knife was the one that was
Let's take a Swiss
recovered.
Army knife. You're saying that they're not covered. You can go to almost any store these days to get a Swiss Army knife. It is not a gravity knife in your view. And if all they say is that it locks in place, to you, that doesn't mean that it fits this statute.
It can't fit the statute. The language would be superfluous. It must lock into place by a mechanism that must be deactivated. The mechanism must be deactivated to close
That's
it.
not in the statute.
It's not,
Well,
but
doesn't this still fall into that language about an overly technical reading of the misdemeanor complaint? And at this point, whether it's friction that locks it in places or an actual button locks it in place, I don't know if that's really your strongest argument. What I'm wondering about is in the Dryden case, they talked about the officer stating his experience and the basis for this. And what do you have to say about that point?
well, they didn't allege training and experience here, and certainly we would have been closer to reasonable cause if they had. We don't know if this
He alleges
officer,
that he used it.
personal testing
Says, I
alone.
used it myself
Right.
in a way that made me determine that this is a knife that falls within the penal law.
But that doesn't give us any
Why
assurance.
isn't that good enough?
Because it doesn't give us any assurance that this officer knew the difference between a gravity knife and a common folding knife. And actually, it is a tricky,
So for purposes of a misdemeanor complaint, he's got to give a rendition of his extensive experience and how he's able to determine one knife from the other when he uses it?
I'm not saying he has to go through and say, I had training in X, Y, and Z on these dates. Perhaps a recitation of training, I had training and experience in the identification of gravity knives, plus I tested it, plus this is what led me to believe it was after I tested it. That would be ideal. The switchblade is also an illegal.
You say that, I just want to stop you for a second. You say that would be ideal, and we would probably agree with you. But is that what's required? Does it have to be ideal?
I think there has to be, it's a case-by-case basis, meaning certainly here, if he had, I think if you're alleging training and experience and personal testing, you need to give the basis. If you're not alleging any training experience, or you're not alleging, you can maybe perhaps can give less detail.
Well, does
So it's-
Dryden require that you must describe the training and experience?
Taken literally, yes, it does. And
But I think it says with reference to.
Yes.
Does that mean I have to explain it if I'm the police officer?
you perhaps referring to it as I indicated would be enough. But you would still need to give the basis for your conclusion, personal testing plus the basis for your conclusion, so that we can be assured that a crime has been committed.
Wasn't the focus in Dryden that there were no facts at all? It was just a conclusion that this was a gravity knife?
Yes, so we didn't have reasonable cause to but here, you can't just say it's a red knife. That wouldn't be reasonable cause. Just giving additional facts is not going to give you reasonable cause. We need reasonable cause that this knife operated in an illegal manner and fits the definition of a per se.
Okay, counsel, let's hear from your adversary, and then you'll get rebuttal.
Good afternoon, Your Honors. May it please the Court.
Counsel, is your adversary not right that this complaint could be drawn a little better than it was?
Your
A
Honor,
little more specific, or is it perfect the way it is?
Your Honor, it's fine the way it is. I mean, the complaint,
You know what I'm saying.
Can-
Could it be a little bit better drawn with
Your
a
Honor,
little more
is it-
information?
yes, Your Honor, it does not need to be better drawn in order to satisfy reasonable cause. Reasonable
Yeah, but that's
cause,
how I ask you. They could do a better job on the complaint, right?
Your Honor, I mean, there could always be more specifics and more facts and more
But you're
explanations.
saying it's all that has to be there.
Yes, Your Honor, and this case is
Can we
clearly.
call it a gravity knife from the description?
Absolutely, Your Honor. This case is clearly distinguishable from Dryden, and in fact, it represents our office's effort to comply with Dryden, because in Dryden, this court ruled that it was strictly conclusory because there was no basis for the officer's knowledge. Here, we do have basis for the officer's knowledge.
What's the basis for
The
the
basis is that he personally handled and personally tested the knife, and he came to two determinations. One,
But her argument is that there's no way from the complaint to know whether or not the fact that he tested it really establishes that he could, through that process, have determined that it's a gravity knife.
Your Honor, I disagree with that. When he tested the knife, he came to two determinations. The first determination is that it opened with centrifugal force, and the second determination that it locked automatically in place. Automatically is...
The argument stands that, there are other knives that seem to mimic these same requirements of the statute, but that are not gravity knives. And that merely saying, oh, I used centrifugal force and it locked, may not indeed really explain or describe a gravity knife. And without the officer saying more than, well, I used it and it acted like a gravity knife, doesn't give the appropriate notice about the basis for that determination.
Your Honor, the understanding is that the defendant was given sufficient notice, and because and the language, even if the language did not state, for example, automatically, it is our position that it would still be sufficient because we are dealing here with reasonable cause, which is a less stringent standard.
Then proof
beyond a reasonable doubt. Exactly. If there is any additional facts that the defendant wants to portray, or something against the officer or anything like that, that could come out at trial.
If he wants to show that he's mistaken in his conclusion.
Exactly.
That's not a question that has to be resolved through some articulation by the police officer in the complaint.
Absolutely not.
That's a question for the trial.
Exactly, Your Honor.
Your opponent's argument, if I understand it, is what he said was, just as you said, it opens with centrifugal force and locks automatically in place. She's saying that's fine, except what it says is when released is locked in place by means of a button, spring, lever, or other device, and that part is missing from this, and therefore it's jurisdictionally defective.
Yes, Your Honor. By stating in the complaint that the knife locked automatically in place, by stating the word automatically, that is essentially synonymous with a device or mechanism.
So the legislature, when they put this stuff in, it's surplusage.
No.
They didn't have to say button, spring, lever, or other device.
No, Your Honor. It's not surplusage. But when we're using it here in the complaint for the purposes, again, given a fair and not overly restrictive reading, the term automatically is synonymous with a mechanism. It does not become surplusage. It is not meaningless.
Sufficient to give them notice?
It is absolutely sufficient to give the defendant notice.
What about the Dryden directive? I won't say it was a requirement, but a directive that the police officer explain or give some experience about how that officer knows it's a gravity knife, as opposed to maybe me, who pulls out a knife and I don't know whether it's a gravity knife or some other kind of knife.
Your Honor, there was no need here in this complaint to mention training and experience. And the reason why there was no need to mention training and experience is because the officer personally tested the gravity knife. He personally tested, he has personal knowledge that this indeed is a gravity knife.
What if it's the first time he's ever handled a knife?
Your Honor.
How do you know that he knows that this is a gravity knife?
Well, I would think that if the officer is...
Again, given that there are other knives that apparently mimic some of these elements of a gravity knife.
Your Honor, I'm sure that in order to state in the complaint that this is a gravity knife, I'm sure that the officers are trained.
All officers are sufficiently trained to know a gravity knife when they see it?
Well, no, it's not it's not necessarily when they see it. Here we have much more.
All officers, when they push the button or whatever they do,
right, Your Honor,
they all know that that's a gravity knife?
If the officer is affirming in the complaint that this is a gravity knife, not just by testing it, oh, I tested this, and just by testing alone, this is a gravity knife. He came to two conclusions.
If the officer got on the stand and testified, I saw the defendant coming out of Target, and I know that he bought a Swiss Army knife, and that's a gravity knife, and therefore he's guilty. And on withering cross-examination, counsel said, did it have a button, spring, lever, or other device that would hold it in place? And he said, I don't know. Would he be acquitted?
That's a very good question, Your Honor. Again, I don't know if he would be acquitted.
Don't you have to establish each and every element of the crime charged in the original charging instrument?
That is correct, Your Honor. But again, as you mentioned, that is an issue for trial.
No, I'm suggesting it might not be. I mean, in other words, if he just gets on the stand and testifies, I tested it and it's a gravity knife, and they moved to dismiss on legal sufficiency, and they said, well, based on People versus Sands, I don't think that's legally, I think it's legally sufficient. He then testifies to what he said in the complaint, but he does not say that there was a button, spring, lever, or other device. Would he be acquitted?
Well, Your Honor, if he testifies at trial and he testifies that he tested this weapon and this weapon opened with centrifugal force, but then when it came time to locking in place, if he said that he does not know or that it did not lock by any kind of device, then yes, the jury could have a determination to acquit him. But again, here, this language, it does not, him saying it locks automatically in place does not negate by any means that there was a device involved.
At this point,
It does the opposite.
At this point, do you have to establish every element of the crime
No, Your Honor.
in the misdemeanor complaint?
No, Your Honor.
It doesn't have to charge each and every element of the crime charged?
Your Honor, we have here each and every element of the
No,
crime.
but
That's
that
right.
doesn't answer the
Right.
question. Does, at the point of a misdemeanor complaint, do you have to establish every element of the crime?
Your Honor, I believe that it's within information that you have to establish every element of the
That's what I
crime.
was getting at.
Yes.
What's the difference between the information and the misdemeanor complaint in terms of what you have to establish?
The difference is that with a misdemeanor complaint, you have to establish reasonable cause to believe that this person committed this crime. So what it is here.
And with the information?
And with the information, you have to establish if every fact.
That each and every element of the crime, right?
Yes, and in fact, if every fact is true, would it establish every element of the crime? Correct. So, and reasonable cause is essentially, as I mentioned earlier, is probable cause. So when you're looking at it as probable cause, essentially it's, did this officer have probable cause to arrest this defendant by after testing the weapon and after determining.
Wait. Let me. In the beginning, he says at the above date, time, and place, the deponent observed the defendant in possession of a gravity knife, and the deponent observed the defendant remove a knife from defendant's pocket, and the deponent recovered said knife from the defendant. That's enough, right?
That he recovered the said knife from the defendant after testing it?
There was a gravity knife. No, just what I just read you. He said the defendant was in possession of a gravity knife.
Well, Your Honor, in Dryden, you ruled that that was not enough.
That's my point. But you were saying all we got to do is establish probable cause. Well, if a cop says I took a gravity knife off somebody, sounds like probable cause to me. But I think what we were saying is that you got to allege a crime. And in order to allege a crime, you got to establish the elements of the crime.
And here it's sufficient to allege a crime, Your Honor.
Well, we're
and
close.
We're saying that locks automatically in place. And when we say that, we're using the language directly from Dryden.
So you want to say that locks automatically in place is the equivalent of what I just keep reading here about levers, buttons, et cetera?
Absolutely, Your Honor. Okay. And getting to right.
Because as you say, automatically is synonymous with there is a device that locks this into place. Whatever that may be. Maybe a button,
yes.
Maybe a spring, some other device.
Correct.
Language says
the definition of automatic is having a self-regulatory mechanism.
Okay, counsel.
So that by itself.
Thanks, counsel.
Yeah. Thank you, Your Honor.
Okay. Rebuttal. Counsel. Counsel, does she have to establish, does the people have to establish every element of the crime in a misdemeanor or the complaint?
Yes, they need to allege every element of the crime. Otherwise, you don't have reasonable cause that the crime has been committed, and you leave open the possibility that people are getting arrested and charged.
Opposed to an information?
Non-hearsay allegations, establishing every element of the crime, obviously.
Information, yes.
That's an information. But in this case, without establishing these elements, we don't have confidence that a crime has been committed. And these are cases.
Talking about training and experience establish an element of the crime.
It brings us a step closer to having confidence in the in.
Well, that's reasonable cause. That's not an element of the crime.
It brings us a step closer to having confidence in the officer's assertion that it meets every element of the crime. That's what it brings us closer to. But this officer, it could have been me testing the knife. We don't know his training and experience. He didn't allege any.
You're not impressed with the argument about automatically?
No, actually, and I can speak to that. A self-regulating mechanism can be the sheath and the blade. You know, it's not a spring lever button or device. And I will point out the switchblade. It's not a button, spring, lever, or device, which is the statutory
What
language.
else does
It's
it
a
mean?
mechanism.
What else does it mean?
It could be a bias toward remaining open. It could be the friction between the blade and the sheath. But I'm going to point out
In
this.
those examples, don't you then have to manually
Then you have to manually
close
close
it?
them.
But with the lever device, is it that you use the device again to close it?
Oh,
Or is
yes.
it also manually?
No, you're right. There would be something that needs to be deactivated, meaning pushed,
Gravity
pushed,
knife,
slid.
you have to
yes.
choose.
You have to
activate,
choose.
and you have to choose to deactivate. But in
Exactly.
your examples, these other examples, it's something external to the person. It's not a, right?
Correct.
That may keep it, what you're arguing, in a locked or open, it's really you're arguing it's in an open position, and it will not move from that position.
Right.
Until you use some manual force to close it other than a device.
Right. And switchblade is under this, it's a per se legal weapon under the same statute, and that says the blade is released automatically by means of a button, spring, or other device.
How does it go back in?
I'm sorry, for which kind of knife?
Switchblade.
A switchblade, you can push it back in.
You push it manually.
But
on the gravity, it's all automatic, right?
the gravity, you have to,
It's the device that drives the opening and the closing on a gravity knife?
a device drives certainly the closing, yes,
On a gravity knife?
on a gravity knife. Yes. So under the switchblade language,
Last thought, counsel. Your red light is on.
automatically released from the handle by means of a button, spring, or other device for a switchblade, automatically, and they still require a button, spring, lever, or other device under that statute. Certainly you could not allege possession of a switchblade without alleging a button, spring, lever, or
Okay,
other
counsel,
device.
thanks. Appreciate it. Thank you both.